Hello everybody, my name is Renju Thomas. I am working as an assistant professor of law at National Law University, Jodhpur. Today I am discussing about the module Judicial Approach in relation to Dowry Prohibition laws in India. As a prerequisite, a general understanding of substantive and procedural law relating to dowry prohibition is needed for this module, and the objective is to understand the legal implications of the term dowry. Second, to understand the substantive and procedural elements of the law relating to dowry prohibition in India. And the third objective is to critically analyze the judicial trend in interpretation of dowry prohibition laws in India. Let us start. The purpose of this lecture is to demonstrate and trace the development of the substantive and procedural criminal law relating to issues of dowry and to critically evaluate the judicial sensitivity and its connection to an reflection upon the social reality of dowry deaths in our country. If we analyze the most important trends of judicial interpretation in cases related to dowry deaths are also mapped out so as to determine the exact scope of the rights that can be enjoyed by the women to protect themselves against this heinous and barbaric crime against humanity perpetuated in the name of culture. In this, first we are analyzing the legal provisions and interpretation. Section 304B of IPC defines in express terms the offence of dowry death. To understand the true import and the circumstance when said offence is deemed to be committed, we must read the definition given under the Indian Penal Code in conjunction with Section 2 of Dowry Prohibition Act 1961. A close perusal of Section 2 of the Dowry Prohibition Act 1961 shows that this definition of dowry can be broken into 6 distinct parts. The first one, the dowry consists of any property or valuable security. Here the word any is a word of wide ambit and would therefore include within it any property or valuable security of any kind whatsoever. Second, such property or security can be given or even agreed to be given. The actual giving or such property or security is therefore not necessary. Third one, such property or security can be given or agreed to be given either directly or indirectly. Such giving or agreeing to give can again be not only by one party to a marriage to the other, but also by the parents of the either party or by other persons to either party to the marriage or to any other person. It will be noticed that this clause again widens the reach of the Act insofar as those guilty of committing the offence of giving or receiving dowry is concerned. Such giving or agreeing to give can be at any time. It can be at before or at any time after the marriage. Such giving or receiving must be in connection with the marriage of the parties. Obviously, the expression in connection with word in the context of the social evil sought to be tackled by the Dowry Prohibition Act. Prohibition Act mean in relation with or in relating to. It has to be noted that causing dowry death under Section 304B IPC attracts the lesser punishment of minimum 7 years imprisonment to life imprisonment and not the imprisonment or death as under Section 302 IPC, that is punishment for murder. Because under the former section, the court proceeds on the basis of presumption and not positive proof. However, if there existed a positive proof that the husband or his relative killed the woman, the husband or relative would be liable for murder and not merely dowry death under Section 304B. We can see that in Gurdeep Singh versus State of Punjab, the Supreme Court held that though the expression presumed is not used under Section 304B IPC, the words shall be deemed carry literally and under the law the same meaning since the intent and context require such attribution, and it is a mandatory presumption or in other words of shall presume variety. Further, it is to be noted that while interpreting the scope of the said section, that is 304B IPC, the courts have repeatedly held that the term relative of the husband in a criminal statute like Section 304B should be given a restrictive interpretation, and the phrase therefore it refers not only to a person related to the husband of the said women either by blood, marriage or adoption, although the definition of the practice of dowry and the offence of dowry death on a bare perusal of the said sections appear direct and simplistic. To understand, even the Supreme Court of India has faced several difficulties in determining what demands and exchanges exactly fall within the purview of the term dowry as legally defined. Under the Dowry Prohibition Act, and as to what is the time frame within which the cruelty or harassment to which a married woman is subjected to relation to dowry so as to be called as being committed in court soon before her death, the difficulties in the interpretation of these two phrases occurs mainly because it is both logically and legally impossible to provide an exhaustive list of the circumstances, situations, acts or events that shall always be deemed to be covered by the use of the said two phrases. By their very nature, their scope is to be determined on the basis of the facts and circumstances of each case that comes up for the adjudication before the courts. In an extremely intriguing case of Appa Sahib versus State of Maharashtra, the Honorable Supreme Court construed the definition of dowry strictly as it forms part of Section 304B, which is in turn a part of a penal statute. The court held that a demand for money for defraying the expenses of manure made to a young wife who in turn made the same demand to her father would be outside the definition of dowry. The court here observed as under a demand for money on account of some financial stringency or for meeting some urgent domestic expenses or for purchasing manure cannot be termed as a demand for dowry as the said word is normally understood. Evidence adduced by the prosecution does not therefore show that any demand for dowry as defined in Section 2 of the Dowry Prohibition Act was made by the appellants. As what was allegedly asked for was some money for meeting domestic expenses and for purchasing manure. Interpreting the incidence of dowry in such a restricted and narrow sense is capable of destroying all efforts to achieve the object of the act, and therefore, when analyzed critically, the judgment in the case of Appa Sahib has no ratio, and it can correctly be said that decision of Appa Sahib holds true only in Appa Sahib. This explains why Appa Sahib judgment was distinguished in at least 4 other judgments, but however it was followed in Vibin Jaiswal versus State of Andhra Pradesh. The Supreme Court in Rajinder Singh versus State of Punjab discussed in length as to how a statute of this kind needs to be interpreted. The court was of the view that the judgment in Appa Sahib's case followed by the judgment of Vibin Jaiswal did not state the law correctly. The court held that the statute must be given a fair, pragmatic and common sense interpretation so as to fulfill the object sought to be achieved by the Parliament. Therefore, any money or property or valuable security demanded by any of the persons mentioned in Section 2 of the Dowry Prohibition Act at or before at any time after the marriage which is reasonably connected to the death of a married woman would necessarily be in connection with or in relation to the marriage unless the facts of a given case clearly and unequivocally point otherwise. Reference can also be made to the decision in the case of Reema Agarwal versus Anupam, in which the court, while construing the provisions of the Dowry Prohibition Act in the context of Section 498A of the IPC, applied the mischief rule made immortal by Hayden's case and followed Lord Denning's judgment in Seaford Court Estates Limited versus Asher. The Supreme Court in the same case given an expansive meaning to the word husband occurring in Section 498A IPC to include within its scope persons who entered into a relationship with women even by feigning her to be husband. This rationale is in continuance of the above stated general principle which is to be interpret the law so as to give greater meaning and lifeblood to the object of the statute, outlawing the practices of exchange of dowry. The expansive meaning given to the term husband is justified in several cases by the judiciary on the ground that the object of the said section was not to test the validity of the marriage, but rather to protect an unoffending and innocent woman from the evils associated with the demands of dowry. What is soon before her death and its judicial interpretation? We will analyze here. The words soon before appear in both section 304B IPC and in section 113B of the Indian Evidence Act. For the presumptions contemplated under these sections to apply, it is necessary to show that the cruelty or harassment was caused soon before the death to a woman. In relation to demand for dowry, the interpretation of the words soon before is therefore important in order to fix liability under these sections, because if cruelty or harassment of such nature could not be said to occur soon before her death, the nexus between the causes of death and the demand for dowry would appear to break. The question then is, what time is to be termed as constituting soon before her death? Is there any numerical formula to calculate the same in the term of number of hours, days or months? The court, in a line of several of cases, have held that the scope of the word soon before her death would depend on the facts and circumstances of each case that comes up for adjudication. The instances of cruelty or harassment differ from case to case. Every instance of cruelty and related harassment has a differing and varied impact on the mind of a woman. Some instances may not be grave as to have a lasting impact on a woman and may be forgotten momentarily, whereas some other instances which degrade her dignity may remain etched in her memory for a long time. Therefore, soon before her death is a term that bears a relative meaning. In matters of emotion, there cannot be fixed mathematical formula that determines with precision the consequences of each act of cruelty or harassment on a woman. The time lag may differ on case-to-case basis. If the cruelty or harassment or demand for dowry is shown to have persisted, it shall be deemed to be soon before her death. And if any other intervening circumstances showing the non-existence of such treatment is not brought on record before such alleged treatment and the date of death, it does not, however, mean that such time can be stretched to any indefinite period. A proximate and live link between the effect of cruelty based on dowry demand and the consequential death is required to be proved by the prosecution in each case to bring home liability under section 304B of IPC. Thus, there must be a nexus between the demand for dowry, cruelty or harassment based upon such demand and the date of death. The Supreme Court in Dinesh versus State of Haryana held that the term soon before is synonymous with the term immediately before. However, it was held not to be a correct reflection of the law in Reginder's case. Soon before was held not to be synonymous with immediately before in Reginder's case. Suicide as dowry death otherwise than under normal circumstances. The Supreme Court has effectively clarified the many doubts that were raised continuously about the nature of death for which section 304B would be applied. A landmark decision was given in Public Prosecutor Andhra Pradesh High Court versus T. Punaya, where suicide, though committed by the victim herself, was considered to fall under dowry death as envisaged by section 304B of IPC, provided the other ingredients of the section were fulfilled. The court once again reiterated in the same case that irrespective of the mode or method of the cause of death, if the death occurs within 7 years and the death is unnatural, homicidal or suicidal, the provisions of the said section 304B of IPC would apply. The court rejected the contention of the counsel of the accused, who argued that the medical evidence showed that the death was due to asphyxia on account of hanging, and that section 304B does not apply to cases of suicide. The court held that section 304B applies where the death of a woman is caused by burns or bodily injury or occurs otherwise than under normal circumstances, provided other conditions are satisfied. Since the death of the deceased was on account of hanging, it was still death otherwise than under normal circumstances. And even if she had committed suicide by hanging, the death would still fall under section 304B as long as it can be shown that soon before her death she was subjected to cruelty or harassment by the in-laws in connection with any demand for dowry. The view that section 304B can also be applied to suicide was reiterated by the Supreme Court in Shanti versus State of Haryana. In such cases, section 304B is applied and this position is no longer disputed. Burden of proof and dowry related offences. As the dowry related offences targeting the death of young women taking place within their matrimonial home, and often the culprits are the husband and the in-laws. There will be practically no direct evidence available to nab the guilty. The traditional principles of criminal law or the criminal justice system based on the presumptions of innocence of the accused and requirement of proof beyond all reasonable doubt, which were the quintessence of the justice delivery system, proved to be undoing of the system in tackling organized crimes and other special offences. To meet the extraordinary situation, section 113A and 113B were added to the Evidence Act. A bare reading of the section 113A of the Indian Evidence Act shows that to attract applicability of section 113A, it must be shown that the following elements are all satisfied. 1. The woman has committed suicide. 2. Suicide has been committed within a period of 7 years from the date of her marriage. Third one, the husband or his relatives who are charged had subjected her to cruelty. On existence and availability of the above said circumstances, the court may presume that such suicide had been abetted by her husband or by such relatives of her husband. The phrase may presume used in the section 113A is defined in section 4 of the Indian Evidence Act, which says, whenever it is provided by this act that court may presume a fact, it may either regard such act as provided unless and until it is disproved or may call for proof of it. The court should be extremely careful in assessing the facts and circumstances of each case and the evidence adduced in the trial for the purposes of finding whether the cruelty meted out to the victim had in fact induced her to end the life by committing suicide. If it transpires to the court that a victim committing suicide was hypersensitive to ordinary petulance, discord and difference in domestic life quite common to the society to which the victim belonged, and such petulance, discord and difference were expected to induce a similarly circumstanced individual in a given society to commit suicide, the conscience of the court should not be satisfied for basing a finding that the accused charged of abetting the offence of suicide should be found guilty. If all the conditions mentioned in section 304B are present, then there is a presumption that the accused has committed the crime of dowry death. This presumption is created by section 113B of Indian Evidence Act, inserted by the Act 43 of 1986. Not only section 304B enjoys a mandatory statutory presumption of the guilt of the husband, as the words shall presume as used in the said section, on the proof of eventualities as mentioned therein. Section 113B of the Evidence Act fortifies such presumption in the probative perspectives. The Supreme Court of India has delivered a landmark decision in the Gurbhajan Singh versus Satpal Singh, which made the application of the section 113A and 113B of the Indian Evidence Act retrospective. The court held that the provisions of this section do not create an offence, and since no new offence is created, it is merely a matter of procedure of evidence and it may be made retrospective. other provisions in the Indian Penal Code for the protection of women. Section 498A and 306 of Indian Penal Code are substantial provision protecting the important rights of women, particularly within the context of marriage. It may be noted that the word dowry does not occur anywhere in section 498A, either in main part or in the explanation. Hence, the willful conduct or the harassment coming under clauses A and B may or may not be related to dowry. Hence, the definition of cruelty is much wider and is not confined to dowry harassment. Section 498A IPC vis-a-vis 306 IPC. Both the sections are independent and constitute different substantive offences under the criminal law. Though, depending on the facts and circumstances of an individual case, subjecting a woman to cruelty may amount to an offence under section 498A and may also, if a course of conduct amounting to cruelty is established, leaving no other option for the women except to commit suicide, amount to abetment to commit suicide. However, merely because an accused has been held liable to be punished under section 498A IPC, it does not automatically follow that on the same evidence he must also and necessarily be held guilty of having abetted the commission of suicide by the women concerned. Section 498A IPC vis-a-vis 304B IPC. The Supreme Court, in its decision in the case of Srimati Shanti versus State of Haryana, pointed out that the difference between section 304B and 498A of the Indian Penal Code, and that though they may contain offences that have cruelty as the root cause, they are essentially separate and distinct, and charges have to be filed under both the sections. In this case, before the court, as per the facts, the deceased was alleged to have committed suicide, and simultaneously the conduct of the in-laws after the death of the daughter-in-law was extremely suspicious. They hastily cremated her even without informing her parents, and in the absence of material which could indicate a case of natural death, the High Court convicted the accused under section 304B and dismissed the charge of section 498A. The accused came to the Honorable Supreme Court of India and contended that the very fact that High Court acquitted them under section 498A means that there was no proof of cruelty. The Supreme Court held that cruelty is a common condition in both the sections, and it had to be proved as an element for constituting an offence under each of them. In section 498A, the meaning and import of the term cruelty is explained, but no such explanation is given in sections 304B. Given the common background of enacting criminal provisions as regarding these offences, the meaning of the cruelty and the harassment under section 304B falls under the same interpretation as section 498A, under which cruelty by itself is punishable. The difference between the two sections, as in the opinion of the Supreme Court, was that in section 304B, the incidence of death is punishable when it occurs within 7 years of marriage. No such period is mentioned in section 498A, and the husband and in-laws are liable any time after the marriage. This means that the person charged and acquitted under section 304B can be convicted under section 498A. But from the point of view of practice and procedure, and to avoid technical defects, it is necessary in such cases to frame charges under both the sections, to avoid a situation where the accused is acquitted merely on technical grounds. Next, we will discuss about misuse and constitutionality of section 498A of IPC. The constitutionality of section 498A is often challenged due to its widespread misuse. However, the courts have time and again dismissed such claims and held that the provision is valid. In the case of Sushil Kumar Sharma versus Union of India, the Honorable Supreme Court dismissed the claim of husband who alleged that This section is quite often misused by women and hence unconstitutional. The court opined that mere possibility of misuse did not render a provision invalid. In the above judgment, though the Honorable Supreme Court has upheld the constitutionality of section 498A, the court recognized the fact that this provision of Indian Penal Code could well be misused. In Inder Raj versus Sunitha, validity of section 498A was challenged on the grounds inter alia that this section provides arbitrary powers to the police and the definition of cruelty is unconstitutionally vague, and that it violated the right to equality under Article 14 of the Constitution of India. The Delhi High Court, however, upheld the provision, stating that the word cruelty is well defined in the law and its interpretation would therefore not be arbitrary. Also, in the case of Krishan Lal versus Union of India, the High Court of Punjab and Haryana held that section 498A did not violate Article 14 of the Constitution. The court held that Article 14 requires that all persons similarly situated be treated equally. However, the government may differentiate among people based on reasonable classifications. The court further held that the classification of a husband and his relatives for the purpose of imposing criminal punishment is reasonable, especially when the alleged violence takes place within the marital home where it is difficult to gather evidence. In the case of Verulu versus the state, the court demanded a stop to the unhealthy trend of false complaints that had been resulting in unnecessary misery to the husband and his relatives. In the case of Sapneshwar Dahuri versus state of Orissa, another court observed that the killing of daughters-in-law for the non-fulfillment of demands has undoubtedly become rampant, but noted that even in a case where a young bride dies a natural death, eyebrows are raised and suspicion is immediately cast on the in-laws. Cruelty under section 498A is a non-bailable and is also a non-compoundable offence, and misuse of the section can lead to illegal arrest and imprisonment of innocent people and thereby stigmatize and put them to mental and physical hardships. The Malimat Committee on the Criminal Justice System reported that section 498A helps neither the wife nor the husband in a domestic violence situation. It said reconciliation or return to the marital home becomes practically impossible as a result. For instance, even if the petitioner wishes to make amends by withdrawing the complaint, she cannot do so because the offence cannot be withdrawn. Thus, men accused of inflicting cruelty against their wives are unlikely to return to a normal family life. In 2011, the Rajya Sabha Committee on Petitions, in the light of the Malimat Committee report, admitted a petition against misuse of section 498A, which anchored many progressive women's organizations who claimed that the misuse was a result of the careless investigation by the police. They contended that any amendment to section 498A would be a regressive step in women's rights laws in India. In their view, the possibility of a large number of women falsifying incidents of violence and harassment is unlikely and difficult to believe. For instance, Amnesty International remarked that the Malimat Committee furnished no data to indicate how frequently section 498A is being misused. This logically indicates that the committee's recommendations were founded on rumors rather than empirical research. Importance of circumstantial evidence in cases of dowry death. Several observations have been made by the Supreme Court of India on the appreciation of evidence and the correct judicial attitude that should be adopted when dealing with and deciding cases pertaining to dowry death, given the circumstances that surround the commission of the said crime. In Prakash versus State of Punjab, the court noted that it was the court's duty in cases of death because of torture and demand for dowry to examine the circumstances of each case and evidence produced by both parties for the purpose of
investigating how the death in question took place. While judging the evidence and the circumstances of the case, the court has to be conscious of the fact that death connected with dowry take place inside the house where the husband's family are the only witnesses present. Therefore, the finding of guilt on the charges of murder has to be recorded on the basis of circumstances of each cases and the evidence produced before the court. The Supreme Court also observed that the legislative intent behind the incorporation of Section 113A in the Evidence Act and Section 304B in the Indian Penal Code were to be strengthened prosecution for a crime in which witnesses are not generally available because the crime is committed within the privacy of the home. Inherent in Section 113B is a powerful presumption whereby the court presumes the accused to have committed the offence of dowry death. If the prosecution can successfully show the existence of all the conditions required under Section 304B, accordingly, in Hemchand versus State of Haryana, the judge observed that a complete and holistic reading of Section 304B would show that when a question arises whether a person has committed the offence of dowry death, what is necessary to be shown is that soon before her unnatural death, which took place within 7 years of marriage, the deceased had been subjected to cruelty or harassment for or in connection with demand for dowry. At this stage, the presumption under Section 113B is applied, and thereafter the burden of proof shifts on the accused to prove his innocence as regard to the said offence. Therefore, irrespective of the fact whether the accused has any direct connection with the death or not, he shall be presumed to have committed the dowry death. In the above case, the prosecution proved unnatural death without direct evidence connecting the accused with the actual death. Nevertheless, the court convicted him but decided that the absence of direct evidence was a mitigating factor in his favour and thereby ordered a reduced term of sentence. Judicial trend relating to dying declaration in dowry death cases. Dying declaration or a statement is made by a person who after making the statement dies. Such a statement is an exception to the general rule that hearsay evidence is not admissible evidence unless such evidence is tested by cross-examination. Under Section 32 of the Indian Evidence Act, when a statement is made by a person as to the cause of his death or as to any of the circumstances of the transaction which resulted in his death, in case wherein the cause of the death of that person comes into question, such a statement, oral or in writing, made by the deceased to the witnesses is a relevant fact and is admissible in evidence. Such a statement made by the deceased person is called the dying declaration and falls in that category provided it has been made by the deceased while in a fit mental condition. A dying declaration made by the person on the verge of death has a special sanctity to it, as at that moment a person is considered most and highly unlikely to make an untrue statement. Therefore, a dying declaration has a sacrosanct status as it is verbal testimony given by the deceased victim. Once the statement of the deceased victim and the evidence of the witnesses testifying to the same passes the test of careful scrutiny of the courts, it becomes an important piece of evidence, and if the court is satisfied that the dying declaration is true and free from any embellishments, such a dying declaration by itself can be the basis for recording a conviction even without looking for corroboration. If there are more than one dying declarations, then the court must scrutinize all of them to find out if each one of them passes the test of being trustworthy. They must be consistent on the material particulars before the court can accept and rely upon the same. Non-verbal dying declaration. In addition to the admission of dying declarations as a form of corroborative evidence, the Supreme Court went a step further in Misala Ramakrishna versus State of Andhra Pradesh, where it said that a dowry death recorded on the basis of nods and gestures is not only admissible, but also possesses evidentiary value to the extent that the recorder could positively ensure that the victim could clearly understand the questions and responded after having developed such a sound understanding of what was being expected of him while giving the relevant replies. In a matrimonial dispute, it would be inappropriate to expect outsiders to come and depose. Quite often, the incriminating evidence is available within the four corners of the matrimonial home, and hence is usually not available to anyone outside the occupants of the house. The family members and sometimes the relatives, friends and neighbors are the most natural witnesses. The veracity of the testimony is to be tested on objective parameters and not to be thrown overboard on the ground that the witnesses are related to either of the spouse. However, exception has been taken by the courts that the servants of the house should have been examined, and that amounts to suppression of the best possible evidence. If I am concluding, it can be clearly noted in many dowry-related cases, the primary reason behind dowry-related offence is inability of a woman to effectively resist her in-laws' demands, and if necessary to have a marriage which causes her humiliation. In patriarchal society like that of ours, there is a culture of silence that reinforces an oppressive pressure to keep the marriages going at all cost. This effectively keeps women in abusive homes. Consequently, the IPC, CRPC and the Indian Evidence Act have been amended to sharpen the teeth of law in dealing with this social menace. The courts have to ensure that each case relating to domestic violence should be dealt with proper care and caution. It is imperative that the right interpretations be given to the provisions of criminal laws in the context of specific facts and circumstances. While a male-oriented interpretation which lacks insights and perceptions from feminist perspective can lead to increase in dowry deaths, it has to be noted that there have been cases where women have been used these laws providing legal protection against cruelty and harassment within the institution of marriage as a sword, so as to cause mental and physical hardships to innocent husbands and in-laws. It must always be kept in mind that misuse of law is not an excuse based on which rights can be denied to any women, as rights are objective claims meant to come to the aid of and protect women who genuinely need their assistance in defending their legal and social status and position. The future of dowry laws necessarily depends on community action, public legal education, and sensitizing all levels of the implementation agencies. Perhaps the most important aspect of combating violence against women in our society is providing equal education and increasing economic opportunities for them. Voluntary organizations have a crucial role to play as they have the experience and strategic capacity to provide victimized women with the support services needed to pursue legal action. Such an approach is a must to avoid the issues that led to the failure of Dowry Prohibition Act 1961 in relation of the effective administration and implementation of the criminal remedies available to a victim in cases of cruelty or harassment in connection to demands for dowry and in order to punish the perpetrators of dowry death. It has become increasingly apparent that social change cannot depend on law alone. Both law and society must develop a comprehensive and concurrent approach to eradicating the role of dowry in marriage. Only when such an integrated approach is adopted by the Indian state and its various communities can have an effective realization of women's human rights within marriage can be ensured in its truest sense. For effectively protecting the rights of the female citizens of India, we must purposefully interpret all the laws enacted for protection and safeguard of their most crucial human rights, namely the right to live a free and dignified life. Thank you.